example, are landowners that are out on the landscape and have to live with these decisions. And they contain as much knowledge as anybody, and in most cases more, about the individual resources that they exist with. And so it's important to consider how we protect them and how we protect the data that they generate as well, so that it's not used in a harmful way against them. I'm looking forward to this panel this afternoon to get into this issue and talk about some of the complicating factors that bring rise to data privacy. This extends beyond natural resource management, obviously, but I am excited to hear the perspectives of our panel this afternoon. Lisa, would you please get us started? Well, before we do that, let me give an introduction, and then I'll allow you to talk about your priorities as it relates to data privacy as we go on. But we have Lisa Reynolds. She's the Assistant Attorney General for the state of Colorado. Bobbie Frank, Executive Director of the Wyoming Association of Conservation Districts. Jessica Crowder, Policy Director for the Western Landowners Alliance. And Shara Howie, Program Manager at NatureServe. So Lisa, would you please give us your perspectives?
Sure, thank you very much. So my perspective is a fairly straightforward legal one in most circumstances. I work for the Attorney General's office in Colorado, and in that capacity, I represent Colorado Parks and Wildlife, the Colorado State Land Board, and I'm the Endangered Species Act counsel for the state of Colorado. So I encounter a lot of questions that have to do with conservation and management and threatened and endangered species. And what we've seen recently, especially working with federal agencies, but also with sister states, is that both federal and state agencies need data to make good management decisions. They need to engage in research, they need to engage in monitoring, they need to engage in tracking, and they can't do that without good data and without contemporary data. But the problem arises because we as state agencies and federal agencies can't protect data typically that we have in our possession. And that's because of state open records acts and the Federal Freedom of Information Act, which is basically an open records act at the federal level. So probably everyone in this room is fairly familiar with how these things work. The Open Records Act, most states have their own. There's typically quite a bit of variation between states in terms of what's covered and what's exempted. But in general, these acts were designed to encourage transparency in government. So if citizens want to understand more about a government decision, what the conversation was in making the decision, what data went into supporting that decision, they should be able to ask the state or the federal government to share that information with them. So it was really a transparency motive. But there's always a flip side. And the flip side for this is that it makes it very difficult for us as agencies to put together comprehensive data sets, because landowners, private landowners, have a whole host of important privacy concerns about sharing data. And that's kind of what we run into as an agency, a management agency. For example, when the Fish and Wildlife Service was considering listing the greater sage grouse, and BLM was designing new management plans to amend its resource management plans in the event that the species was not listed, a lot of leks, which are the basically the breeding grounds for sage grouse, a lot of those leks are on private lands. Sage grouse actually are drawn to wet meadows, for example, in the spring, and in a lot of places in the West, those are also ranch lands or hay meadows. And when there was a concern that the species would get listed, landowners were very leery of sharing information about how many leks or how many birds they were seeing on their lands, because many landowners are concerned about letting the Fish and Wildlife Service know the full extent of the presence of a potentially listed species on their property. And so, landowners were reluctant to share that data with the Fish and Wildlife Service, but they're also reluctant to share with us because of the Open Records Act. So even if we as the state of Colorado said, we're not going to share this with the feds, we need it because we are the agency with jurisdiction over managing this species, we're still subject to an Open Records Act request that says, give me all your data on all sage-grouse leks across the state. We're working on getting some exceptions built into our Open Records Act, and I want to congratulate Wyoming because we're very envious, because Wyoming just successfully adopted an exception to their Open Records Act that does allow them to protect sensitive wildlife data. If we had something like that, and I hope we will at some point in the near future, we could get that information from landowners and be able to protect it from disclosure to Open Records Act requests. The thing that is still a problem, and I know that WGA has been working on trying to figure out how to solve this, is that the Federal Freedom of Information Act doesn't have any exceptions for things like sensitive wildlife data. They have a lot of exemptions, but none of them are really lend themselves to this kind of protection. So when we share data with the Fish and Wildlife Service or the USGS or BLM, we can ask them to sign a confidentiality agreement and they can agree, but that confidentiality agreement is only useful in terms of their voluntary disclosure. They can agree not to voluntarily disclose data, but if they get a FOIA request, they still, even notwithstanding the confidentiality agreement they have signed, they still have to cough that data up. You can't contract around your duties under the Freedom of Information Act. So the reason I have absolutely one slide, let's see if I can get it. I just wanted to show you the language of another exception in our Open Records Act. This isn't about sensitive wildlife data, it's about protection of landowner privacy. And so a number of years ago, the Colorado legislature adopted this exception to the Colorado Open Records Act that says it only applies to divisions of our Department of Natural Resources, but that includes oil and gas, mining, parks and wildlife, state trust lands, all the things that I'm involved with. We are not allowed to disclose any records that would essentially that would reveal the identity of specific Colorado landowners or lands. So if we have data that someone asks for in an open records request that would do that, we either take that data out of what we're going to release or we aggregate it up to a level, whether it's township, county, we aggregate it up to a level that the specific landowner or land cannot be identified. So I think this exception, it's a little bit onerous for the divisions who have to go through data and redact or aggregate information, but I think it's been fairly protective for Colorado landowners. So there is that one kind of protection. I don't know if Wyoming or some of our other western states have something analogous to that. But that's one thing that states can do with specifically to protect private landowner data. I think that's probably my time. So just in closing, I think the point of this panel is to get you to think about the tension between the need for data to meet conservation goals and to meet management goals, whether it's wildlife or plants or other things we work on like aquatic nuisance species. We need data to effectively do our jobs, but we have a difficulty assuring the people who we need to get that data from that we can protect it. So that's kind of the problem that we're facing.
Thank you, Lisa. Next on our panel, we have Bobbie Frank, and it was already alluded to the statutes that the state of Wyoming has adopted related to private landowner data, and Bobbie, as well as many others that are in the room today, worked pretty hard on that statute over a number of years. And so with that, Bobbie, would you please give your thoughts?
Sure. First of all, just a little background on conservation districts in Wyoming. For those that may not be familiar, we are local units of government formed under state statute. We were authorized in 1941. As of today, there's 34 local districts. They're governed by 5-member boards that are elected in the general election. By statute, they represent 3 rural representatives, 1 urban and 1 at large for a cross-section. In Wyoming, our districts have a pretty broad charge in terms of natural resource management, wildlife habitat, water resources, etc. So we do collect a fairly extensive amount of data. Depending upon the district you're in, that can range from wildlife habitat data, water quality data, range data. We have a district doing some predator research, impacts on sage grouse, so it just varies based on the district and their priorities. We work predominantly with the landowners, private landowners. We also are involved in federal land management processes as well. But today I'm going to talk specifically about our data collection with private landowners because I believe that's the topic of interest and certainly is one that we've grappled with some of the same challenges that Lisa just mentioned. Our districts are governed by the Wyoming Public Records Act, so we are governed by those same provisions in terms of the handling, the disclosure, and the exempt from disclosure provisions of that act. I would say in the 90s, our districts really ramped up data collection in terms of water quality data in partnership with our Department of Environmental Quality. And at that time, there was an increasing amount of concern about the fact that all of our data was subject to disclosure under the act, regardless of whether it was collected from a private landowner's lands or not. So there was subsequently legislation several years ago that added provisions to allow for non-disclosure of data that was collected specifically from agricultural operations and landowners who were participating in local programs or programs of the districts to provide an elevated level of protection and increase the comfort level. Again, like Colorado, it can be released on an aggregate geospatial basis, but not a site-specific basis. In all honesty, it's not necessarily been tested on what all types of data it applies to and what data would not apply to, but we're fairly comfortable that it certainly increased some level of protection. I think you could ask several attorneys and you'd get several answers on whether it applied to habitat data or whether it applied to species data or whether it applied to water quality. Our opinion is that we're going to err on the side of non-disclosure when it comes to the data that we collect off of private landowners because our ability to do our job is based on the trust and credibility we have with private landowners. And with that, that leads into my next comments, I guess. And as a private landowner engaged in ag production myself, you're probably going to hear some of that in my remarks related to the importance of the relationship. And the governor talked about the respect and the trust between the Western governors being what leads the Western governors to being so successful. And I would say that same analogy can be applied to conservation districts, our partners with the USDA, NRCS, and our relationship with private landowners. And that is the amount of time and effort we put in our relationships and our trust. That's probably our most coveted aspect of what we do is that relationship with landowners, and we're going to protect it pretty much at all costs because we can't get natural resource management done without it. As Lisa mentioned, there is, I think oftentimes, certainly as a district that's going out to collect data for a specific purpose or charge, or whether you're a state agency or a federal agency and that's your mission and that's your charge, it's easy to lose perspective of the landowner on that data collection, and it's easy to forget what the implications to a landowner can be. And so I think it's important for all of us to remember when we do data collection to come at it from the landowner perspective and the risks to the landowner. The data is important. I think most landowners want to freely participate in helping collect data. Most of them want to help collect the data to show they're doing the right thing, and they have these species on their property for a reason. Having said that, when you collect data and it has the potential implications of property value impacts, regulatory impacts, land use restriction impacts, you can certainly understand the hesitancy of a landowner to allow access. For our districts, we do have a number of different types of agreements in place that we use with our landowners. One, and first and foremost, is access agreements that we're allowed on their property. We have access agreements that are very explicit on what we're going to collect, where we're going to collect it, and how we're going to collect it, so that we're not wandering off. We go to collect water quality data, and pretty soon somebody's over here collecting arrowheads or sage grouse data or something else, and that there's a trust and an understanding of what we're doing and why we're there, and also full disclosure. I often get concerns when I hear conversations between agencies and landowners or representatives who want to collect data for a specific purpose, and it's followed with, but don't worry because there's resources to help deal with whatever the issue may be. Water quality in our case is more often what we're discussing. We can't guarantee resources are going to be there for landowners, and we shouldn't make those kind of promises or commitments when we can't. I think most landowners see through that. They know better than that. And I think to be totally honest and say there's resources there today, we can't ever guarantee they're always going to be there, is probably our best bet, and certainly earns us much more credibility and trust with the landowner if we're upfront. And then as we've listened to the discussions, it made me remember a situation that happened this spring. Because of our conservation district's role in water quality, I wanted to go back. Lisa showed the language that was added in the Records Act. As I mentioned, we have something similar, and it's really mirrored and based off of the USDA NRCS privacy provisions that they have that protects landowner information and data, those that are participating in conservation programs. And I know in the past that language has been defended by chiefs of NRCS very strenuously because they know how important being able to keep that information confidentially is to their ability to do their job. And I think we view this provision that's been put in Wyoming statute the same way. And one thought that I would offer that I think somehow we all need to do a better job at, and that was this last spring, I often get landowners that call me who get asked for access for data collection just because of our involvement in specifically water quality data collection, but certainly other parameters, other resource-based data collection efforts. And this landowner called and said, I have been called by this entity and this entity and this entity and this entity in 1 month. And much of it was all water related. And somehow we need to get more coordinated, whether it's state or federal or what have you. But if you're the landowner and you just got 4 phone calls for folks wanting to collect some sort of information that could have some implications to you, your property values, your management, you get a little overwhelmed, and pretty soon you're just going to shut down and nobody's coming. And it's not because they don't want to be cooperative or participate, but it just gets overwhelming. I can tell you an example that happened to us personally is our state agency had just been out the year before monitoring, and we got a letter wanting access from a federal agency who hired an out-of-state contractor. And when those kind of things happen, it just creates more concern for landowners. And we need to be cognizant of that you're not the only one calling for that access, and you might not have been the only one that called that day. So those are my thoughts, Doug, and those are my one suggestion for working together to collect data and work with landowners.
I think that perspective of Colorado and then Wyoming is really valuable to this conversation. Jessica Crowder is next, and Jessica has a unique background in that she's worked in a number of different industries, but all around private landowner interactions from a multitude of different representative fronts, and now with the Western Landowners Alliance. So, Jessica, what can you add?
Thanks, Doug. And thank you, WGA and staff, for inviting me. I appreciate it, and good afternoon, everyone. My name is Jessica Crowder, and I have to admit I will repeat a lot of what Lisa and Bobbie have already said, but attempt to bring a west-wide landowner perspective to this conversation. As Lisa discussed and Doug did as well, there is a dilemma. The data is necessary. We need data. To make decisions about management, and we need the right data, and we need up-to-date data. Transparency is also important. And the dilemma is, of course, that utilizing data collected on private lands has the potential to be used against the private landowners that allow that data collection, and it also has the potential to threaten not only their livelihoods, but also the very lands that they are protecting and that they are working to conserve and provide livelihoods for them and their families. And so we need to be cognizant of that. But private lands, of course, house important habitat. They are important areas for wildlife species, and also, since they are such a large portion of the landscape in general, they're important from an invasive species standpoint. So in an effort to kind of think about how this impacts landowners, I did a couple of landowner interviews with some of our landowners. We have landowner members, and we are a landowner-led group and landowner-founded. And what really struck me in those conversations with landowners is exactly what Bobbie said, that landowners do want to provide this information. They do want agencies, state, federal, local governments, and even for themselves, they want data. And they recognize the importance of being able to make decisions on management from that data. One landowner expressed to me the importance of data collected from their private lands was incredibly important for avoiding listing of a species, and Tom talked about this earlier this morning in southwestern Colorado at trout species. And without that landowner data, and really landowner data across that portion of Colorado, avoiding listing of the species might have been more difficult. Another landowner in Colorado talked to me about how when they purchased their ranch, they really embraced the idea of allowing data collection on their property. And what that really led to was, again, a trout species, and this is in Idaho, being found in a stream reach that was unexpected. And the landowner was excited about it because it led to some really strong partnerships and some opportunities for technical assistance and for funding to restore some of those stream reaches and the habitats around those streams, and really to improve some of those areas. And so that was a benefit to he and his family and their ag operation, as well as to those interested in the species, the trout species itself. So to echo a little bit of what Bobbie said, a couple things, from our perspective that are incredibly important, relationships and partnerships. Landowners need to know how the data that is being collected will be used. How will that data be used? Where will it be used? Is it just going to the state agency where, as discussed already, there are some safeguards in place, or is it going up to the federal level where the transparency needs increase and the Freedom of Information Act does become a bit of a hurdle, to say the least. The landowner may be worried that an outside litigant could use the data against them, and that's something that those collecting data need to be aware of. But on the, flipping that coin over, data collected across a private landowner's land could also be used to defend the management practices that they have in place. So in that regard, it's important to collect that data and to work together to get that data. I think that respect, which is a word that Bobbie also used, is incredibly important. Respect that landowner is trying to run a business. They're trying to conserve species on their land. They're trying to provide for their livestock and their families. I think that that's incredibly important, and we have to keep that in mind. So really the take home here is landowners do want to do the right thing. They do want the data to be provided so that the appropriate management decisions can be made. And but it's incredibly important to understand ahead of time how that data will be protected, and also to respect that landowner and their lands as well when you go into that type of a situation. And those are my remarks. Thank you, Doug.
Thank you, Jessica. You know, I think all of us could agree that we want all of our management decisions to be based on credible data. It's just this, it's a tricky conundrum in how to do that responsibly and at the right level. I think Shara can provide us with some unique perspectives in that regard about trying to maintain this balance. So if you would please.
Yeah, thank you. I appreciate the opportunity to speak today to all of you. And I get so excited when I hear people talk about data. I think data is underappreciated and often underfunded among the agencies and many that deal with data on a day-to-day basis, like NatureServe does. And I think it's clear from many, many studies, including some that we've been involved with, NatureServe has been involved in with federal highways, that using high quality scientifically based data, especially when you're looking at large landscapes, can save a significant amount of resources in terms of avoiding impacts as well as choosing mitigation sites that will actually have high quality conservation outcomes. So I wanted to just give a little bit of context about NatureServe, because what I find is that people either know, they've heard about NatureServe, they don't quite know what they do, or they've heard of a natural heritage program because they've worked with a natural heritage program in their state. And I wanted to kind of talk about the connection between the two. So we started doing data collection and data management of imperiled species and ecosystems way back in the mid-1970s. And the people that actually do the collection of the data on the ground are the natural heritage programs across the Western Hemisphere. The ones in the US are mostly part of their Fish and Wildlife Agency or non-game agency. It just depends on the state. But NatureServe functions to support that network, and we do it in several different ways. But one of the things that we do is try to put standards in place on how the data is collected and managed. So we have standards on really detailed things like how you map a particular species in order to be able to evaluate that species across its range. So by aggregating this data together annually, as we do with our network programs, we're able to actually assess how the species is doing across its range. And so many federal agencies, I would say most federal agencies in the US actually use our data, G1, G2, G3 species, to help guide prioritization of conservation efforts. In terms of data security and private land ownership, it is a tricky balance. And I'm just going to outline a few different best practices that we've found to be moderately effective. I mean, it's a moving target, as others have said. There's no way to guarantee protection against some of these state open record laws or FOIA, but you can do certain things that help strengthen the ability to protect the data. So one thing that we do, and I think some people get aggravated with us, is that we limit how much data goes out and what it can be used for. So we provide data for, like if Forest Service comes to us and wants to do an analysis across multiple states, we can provide that data under a license agreement. So we're licensing the use of the data to them for a particular period of time, and we outline how they can use the data. And typically we allow the user to use it without restriction within their agency, but they have to limit how they can share it external to their agency. And the reason we do that is to protect the data from getting out into the public domain. We want certain levels of data, like county and watershed scale data, to be out there to the public, but when it becomes more precise and there becomes the data sensitivity issues, that's when we tend to fuzz or generalize the data in some way. So that's one way in which we've dealt with protecting the data, in addition to when we deliver data. So for example, many of our states use an environmental review tool, so the user can screen for potential hits of data, so either invasive species or imperiled species in their area of interest. That's one way to generalize the data, so the user doesn't get the actual map of where the species are, but they know within their area of interest that there is something to be concerned about. And so typically we will recommend, once they get a hit, that there's something of concern there, that they would work with their local heritage program to identify what those species are, or more precisely where they are, if they need to know that. Another thing that we have done, several folks mentioned the state open record laws. Our natural heritage programs have been in the data business for a long time, and so they've worked within their state to develop exceptions, statements like the one that was shown earlier, to help them protect the data from being acquired under state open record laws. And in fact, I talked to our director of the Arizona program yesterday, and she said that they get on average about 12 requests under the State Open Record Law Act in Arizona, and the way that they have a policy or law that they've developed that has shown the test of time, and they've been able to protect the release of data. And interestingly, one of the arguments they use is they only release the data if they show that there's going to be a benefit to the state. So in other words, if the data would be released, it might impact a resource in Arizona that would be a negative benefit to the state, then they can argue that they can withhold the data from release. I think the other thing I would say is that, locally, the state natural heritage programs have a pretty stringent policy of getting permission, obviously, before they collect data. But I think it's also an opportunity to develop relationships with those local private landowners. And I think most of our heritage programs have done a pretty good job in building that trust, and people have talked about trust a lot. And honestly, NatureServe has to prove that we're reliable to our natural heritage programs by being very careful about the way because basically the way NatureServe releases the data is dictated by what the states tell us. So if they say, you cannot release cave data locations to any external user, then we will abide by that, and we'll tell the user if they really need that data, they need to go directly to the heritage program. But there are ways in which they incentivize or create other ways to work with private landowners. And in fact, I think I'd echo what others have said. It sounds to me, I haven't done a survey recently of our natural heritage programs, and I would like to actually to get a better sense of what's happening on the ground and what practices are working in terms of getting access to private land data. But in Idaho, like for example, they give out certificates, and I was surprised. Idaho said that private landowners actually do appreciate that they're getting a certificate that they're contributing to conservation efforts in Idaho. In terms, I would just say too that not only private lands, there's other gaps in our data, like tribal lands, for example. There's some issues around sensitivities of data on tribal lands. And one way, and there's always going to be gaps in data. We're never going to know where everything is. We don't have enough resources to do surveys of all the areas we'd like to, as often as we'd like to. But we are focusing a lot of our attention now on models, and we're developing standard methods in collaboration with many other federal agencies, and working hopefully more closely with Fish and Wildlife Service, but also with USGS and ESRI to develop models for imperiled species. And I know that there is some modeling with BLM and USGS, I think it's USGS, with cheatgrass, for example, and other species in terms of the invasive side of things. So that's another way to deal with, I guess, if you can't get access to the data on private lands, for example, models can help sort of assess where there might be a need to do more work and identify areas of concern. So I guess with that, I will just say that I think there's no guarantees, but I think building trust and building tools that will help with that balance of getting as much data into the hands of users without, impacting negatively the resources themselves is our goal. And we really do. I know it can be difficult sometimes to get access to data through NatureServe. I think some people get frustrated with us, but I think it's doable, and we're still working hard we're working on several tools, as I mentioned, the environmental review tool, to try to get data out there. And in terms of invasives, IMAP invasives, we're working with EDD Maps, who's here, and we would like to strengthen some of those data sets and make those available in combination with the imperiled species data. So I guess I'll close with those comments. Thank you.
Thank you. For anybody on the panel that may have an opinion about this, there have been some pretty highly visible data privacy breaches in the news as of late. This tends to do nothing for the trust between data managers, agencies, and private landowners, as an example. Do any of you have an opinion on how these kinds of situations may be overcome? Does this lie with technology? Is it with legislation, policy? How do you approach something like this?
So this is not an answer to exactly how you do it, but the Colorado legislature in the most recent session adopted a new statute requiring all of our state agencies to have a PPI, which is PII, personal identifying information, set of rules and policies in place for every agency that collects or holds personal identifying information. So we do for a host of reasons, one of which is everyone who applies for a hunting or fishing license in Colorado gives us, among other things, their social security numbers. And so we are developing new policies in conjunction with our Office of Information Technology to, and under a deadline imposed by the legislature, to at least be focused on understanding what technological opportunities we have that we're not taking advantage of, and to be more focused on the dangers of a breach. And it also, the statute has a disclosure requirement. So if there is a breach, anyone whose data was compromised in a breach is required to be noticed within a pretty short amount of time. I think it's 48 hours, but I'm not 100% sure. So that's sort of a policy approach. It remains to be seen how effective it is, but at least there's a focus on it and a connecting of the agencies that hold data with groups like Office of Information Technology that can help us protect it better than we would know how to ourselves.
We have that same duty as agencies of the state of Wyoming. My concern with that is that me trying to come up with a policy that protects personally identifiable information is maybe not the most effective route, because I'm ignorant on how to create those policies. We need a lot of external technical assistance to come in and advise us on what protections need to be in place to really get that done. I don't even know enough to ask them if they're right. I mean, I have to assume that they are, but it's just not a specialty of traditional agencies, and that's a concern that I have. Hopefully we'll get the technical assistance that we need to put the IT policies in place to protect that to a higher degree. Anybody else have any thoughts on that topic before we move on to another one? We don't have a whole bunch of time, but one of the questions that was posed here that I think may help us or give some clarity. Do you have any real-world examples of how a lack of private landowner data has impacted natural resource management decisions for T&E or invasive species, or vice versa? Do you have real-world examples where data was released with an unintended consequence? Anybody willing to discuss that?
Well, I'll jump in. I heard, I was in Sheridan yesterday, and I heard a panel speaking, and we've already heard today, about Medusa Head and Ventonata, and Andrew is here, and not only were they incredibly inspiring, they said something that was very striking, and I think relates to this panel, and it was that the private landowners themselves had come forward. So kind of flipping your question a little bit, Doug, the private landowners themselves had come forward in northern Wyoming and allowed entities onto their places to look for these invasive species, and basically opened the doors and said, yeah, we want to be a part of this conversation. We want to be a part of the management of these species and potentially eradication of these species in Wyoming, and it's important to us. Without that cooperation from those landowners, it would be impossible to reach some of the goals for management that those entities up in northern Wyoming are trying to reach.
I would add, and probably not a direct answer to that question either, but something I failed to cover. in my remarks that I think is important is for our districts, I would say an overwhelming majority of the data that's collected has a funding source that stipulates that it's got to be disclosed either to a state or federal agency. So when we ask for permission from a landowner to collect data, that conversation is had at that point. So the landowner can make that decision of whether they're comfortable with that. I will tell you, the overwhelming majority of the landowners agree to have that data released to the state or federal agency. So I don't have an example because I think more often than not, they're comfortable with it as long as that time's been taken for trust development and then full disclosure's been made of the, you know, the pros and the cons, the good, the bad, the ugly that could happen.
Okay, getting back to kind of along the line of these statutory legislative type proposals, what single statutory or regulatory change, either at the state or federal level, would be most effective in addressing challenges presented by protecting private landowner natural resource data? What needs to happen?
I think, from my perspective, the single most effective thing on a really broad scale at this point would be a FOIA exception, either to protect private landowner data or to protect sensitive natural data. So, I mean, to include both wildlife and plants. But I think an effective FOIA exemption would be incredibly helpful because that way we could share data with federal agencies.
Any other thoughts?
I would agree with that. I think that you'd see even more data collection from private lands if there was a level of security and comfort that the data wasn't going to be released to everybody and their brother.
Can you point to other industries or examples that could be used as templates? You know, which industries are particularly effective at protecting data privacy? Is there anything we can learn from them, and how do we apply their lessons?
Well,
No?
private industries aren't subject to the same open records problems we are. So we share a lot of data with the oil and gas industry when they're making permitting decisions. And we can do it under non-disclosure agreements, and they can protect things under non-disclosure agreements because they're not subject to the same disclosure rules.
I
Okay.
was just going to add to that, Doug, probably the medical field is the one that comes to mind, but I was chuckling because I thought, well, we shouldn't probably use social media or some of those as our examples, or maybe we should learn from them, but I think that probably medical field is something that we should look to if we're concerned, because we're still talking about personal data. It's the same thing, it's just a different resource.
Yeah, certainly. I mean, we've experienced that technology can be a huge asset, but it can also be a big liability. And you know, I don't know if any of you have opinions about do you feel that improvements in technology will help us along these lines of data privacy, or do we need to take a step back from it to better protect privacy?
I mean, in the case of NatureServe, I think it's going to be helpful in the sense of being able to develop these different kinds of tools that provide like screening services and that provide different levels of data security. So for example, we can set up a person's profile that's accessing the environmental review tool or IMAP invasives. Depending on who they are and what they're using it for, we could limit what data they're going to see and what, so the beauty about some of the species data is you can, it's spatial, so you can generalize the location to protect the data. So at a certain scale, the data is not really sensitive. So I think that's one advantage to this type of data and the way technology can actually assist with at least getting some level of information out there to the decision makers.
I would just add a thought on that, and that is, I don't think that technology is the threat to the data privacy. I think it's maybe the loss of the respect and the private land ethic. And so as we have technology, I think we need to accompany that with a continual reminder and education of private property rights and a private land ethic, so that we're respectful of the use of the technology. And I have a son that's armed with a drone, and so he needs to have a drone along with a healthy respect of private property and property ethics and data confidentiality.
Yeah, I would certainly agree with that. One of the challenges I think that we'll face in the coming years is trying to get enough education out to landowners about how these technologies work, what the data says, no matter how it's formatted, no matter how it's compiled. But that's going to be a big challenge that I think agencies like mine can take on. That's a valuable service that a state agency could undertake, and in order to get that kind of information out, so that you're not trying to dupe anybody into agreeing to allow these technologies onto their property, but you're providing a service, a technical assistance aspect, so that you have a higher degree of understanding of what's going to happen out there, and so that you can answer questions that people have. I know, looking at all the array of new technologies that are available to amass natural resource data, I have questions about how that is compiled, how it's stored, how it's transferred, and this is what I do for a living. I mean, all I do is policy work. And so that is something that I think we'll certainly be working on, but I certainly appreciate your perspectives, very valuable. This has been an issue that we've been grappling with for a number of years, and I think that it's just starting to come to the forefront with data privacy. With that, I'll turn it over to the attendees here today, and if you have any questions for the panel, please let us know. Okay. Are we sure?
We did good.
This may be a little bit far-fetched, but I'm going to play devil's advocate here for a minute, and relative to Bobbie's comment, I completely agree and empathize with this idea of trying to remind folks that are trying to collect data of that private land ethic and everything. But I guess I question, and maybe this is where Doug's coming from, with the technology that we have, I think we're stuck in this huge learning phase of a different world, a changing world of the technology can take pictures at a very high scale and start pulling out invasive species populations and some of these other things. And so let's flip that. How can we help message to our private landowners that this may not be comfortable, but this may be happening, and how can we deal with that, and how can we help have that conversation in the midst of still trying to build trust in things with them?
That's a really good point, and I was actually thinking that very thing, because it doesn't take too long. All you have to do is go to your county GIS layer, and you can find out all kinds of things. The day of having complete privacy is long gone for anybody, not just private landowners. So we live in a new world, and we live in a world that has a lot broader disclosure of information about all of us sitting in this room. For landowners, it includes their business and their property that probably have a whole lot more than a typical business would have. I guess my point with the ethics is, even with the accessibility of information and data, and probably because of the accessibility and information of data, I feel like with some of the experiences we've had over the last several years, that somewhere along the line, maybe because of the advance in technology and the advance in the availability of information and data from private lands, that we've somewhat lost that private land, private property ethic. And I just think that needs to become that needs to become part of our training. That needs to become part of our education for natural resource professionals and managers, is that needs to be at the forefront as well. But I agree. I think there's a two-way street there, that you have this information out there and you feed that back to the landowners so they're aware of what issues are out there. Not that they probably aren't already, but it's certainly a two-way street.
And I think I would add to that, Bobbie, because I think that's a good point. If there is technology out there that landowners can be using, then we need to improve communication so that there are ways to get that information back to them so that they can go ahead and use that in their management decisions and see the benefit of it. I think that that's important.
Yeah, certainly. I mean, one of the mantras that we subscribe to at the Department of Agriculture is not to be afraid of any data. You know, this collection of data is very important regardless of what it says. Even if it's telling you something that's a little bit less than flattering, it's better to know that than for it just to exist, because that data will exist anyway. And there's a good likelihood that it gets out in some way. Any other questions for this panel? Or does everybody just want to take a break? All right, next on the agenda is a break, and this break goes until 3:30, so please come back then. Thank you so much.